What is the statute of limitations in a breach of contract claim? In this case, a church contracted to have an addition and renovation of its existing building. In the months that followed completion of the project, water, hail, and even bats penetrated into the church, but the main problem was water infiltration. Repairs over the next 6 years did not fix the problem. In year 7, an engineer hired by the church confirmed the water infiltration problems and noted additional construction errors, including ventilation and insulation issues. The church filed suit, making all claims outside of the 6-year contract statute of limitations for breach of contract. And the trial judge dismissed the entire case before allowing it to be heard. How would you decide this appeal? Should the judge have dismissed the case, or should the church have had its day in court? We'll be back in a moment to answer that question. Can the church bring its claims for breach of contract after the 6-year statute has run? The South Dakota Supreme Court ruled that while the claims for water infiltration could not be pursued, all of the claims brought by the church were not based on that sole issue or cause. Statutes of limitation begin to run when plaintiffs first become aware of facts prompting a reasonable person to seek information about the problem and its cause. The Supreme Court held that the church had actual notice of the water infiltration into the building longer than 6 years. But whether that actual notice was enough to put it on constructive notice of its other structural design and construction error claims was still a question of fact and at the heart of the case. So the case was remanded to the trial court on those issues for a decision by the finder of fact. Remember, it's a matter of law.